Now, we're going to do ethics today in a couple different versions. One is part 1, and that's what I'm going to do. And the second will be part 2, and Christine Tidgren, our staff attorney at the Center for Agriculture and Law and Taxation. My name's Christy Maitre, and I'm the tax specialist. And so I thought it'd be interesting to talk a little bit about the history of the statute. It's a Title 31 statute, and it was enacted in 1884 after the election of the president then, Chester Arthur, and he signed it into law. It was also deemed to be the Horse Act, and we'll talk a little bit about that history in just a minute. And basically, the Act allowed claims to be filed with the Treasury Department on horses that was lost through the Civil War. So it became a really popular thing, apparently, to claim that your horses were lost. And what Congress found out in the Treasury is that there couldn't have been that many horses, okay? So what this law or this statute did is it gave them the authority to admit attorneys and agents. That was before we had CPAs or EAs or any of that, to place claims before Treasury, and it also gave Treasury the right to take appropriate action to discipline if indeed they were not following the regulations or they were incompetent. So through 1921, the statute pretty much remained unchanged, and it only concerned attorneys and specific agents who were representing before the Treasury Department. There really wasn't an IRS back in those days. Then, and I thought you would find this is an interesting picture from the National Archives. In 1921, they combined many of the other statutes into the Circular 230 that now basically became a governing document for representation before Treasury. Now, it wasn't until 1936 that CPAs were allowed to operate like attorneys were and represent clients based on some lobbying efforts. And then in 1951, they allowed other types of public accountant individuals to come in and represent before the Treasury. Then in 1958, the Treasury Secretary decided there's other individuals, and that began the creation of the Enrolled Agent Program. And it really didn't become final until 1966. So the enrolled agent's still an active participant, and were eventually named enrolled agents or EAs. Some other important things happened in that year. Labor Day was created, although it was created in May, it eventually moved to September. We had the birth of some presidential people. Truman was born, Eleanor Roosevelt was born. Cornerstone of the Statue of Liberty was laid after a crowdfunding effort that raised the money to lay it on the island. The Naval College was created in Rhode Island, and the Washington Monument was completed. And it was just in Washington, D.C., and the construction is pretty much done on the monument from the earthquake they had a couple years ago. So let's move ahead and let's find out what's happened in our recent history with Circular 230 and the current regulating of tax professionals. And tax professionals by IRS and the Circular 230 are considered attorneys, CPAs, enrolled agents, those that participate in the annual filing season program, and those that were grandfathered in under the Registered Tax Return Preparer program. And then we also have those that are unlicensed. About 400,000+ are unlicensed and have no representation rights anymore after January 1st of 2016. The whole thing started with the registered tax return preparer, the Loving case, and it wasn't just Loving. You can see the others on your screen. But basically, IRS lost the Loving case, and it negated the ability to regulate those who were not CPAs, attorneys, or enrolled agents. In other words, the unlicensed. Now, what happened during the Ridgely case was in Loving, they really didn't find what it means to practice before the Internal Revenue Service, okay? The courts basically held that IRS did not have, or Treasury did not have the authority to regulate tax preparers or tax professionals who prepare all or substantially all of a tax return. But Ridgely basically defined practice before the IRS. And it is everything that we do before the IRS and Treasury, with the exception of preparing a tax return. That is not considered practice before the IRS, but everything else is. Correspondence, giving advice, things like that. And then finally, we still have, the Steele case. And so that took it to the next step. Someone decided that they didn't think the PTIN program was a valid program and challenged that IRS's authority. And Steele won part of that case. He won the case that there's no authority to charge a fee, but he did not win on the fact that a PTIN must be had. So anyone who prepares all or substantially all of the tax return as a tax professional must have a PTIN. And those are generally a place on the return for those to be placed. So that kind of brings us up to date in some of the history. So let's talk a little bit about ethics in general terms. Okay, there's a lot of different definitions out there, and you can see some of them on your screen, but I've always kind of come to the opinion that it's based in your family values and how you were raised. And you also not only have your personal ethics, but you have business ethics. You have accountability, you have trust from your clients, you behave a certain way in the business world. So, I'll remember which way to go. You're looking at a couple things that we have to deal with on a regular basis. And sometimes it's difficult. We have economic pressures. Most clients are looking for a refund. Those that know they owe, they kind of procrastinate a little bit, but you still have to deal with them. Some people look for a better deal elsewhere. And then you still got to look at the time and effort you put into that tax return and what to charge. And now with earned income credit, we have an extra level of due diligence. And that's also, just to give you a little bit on the new law, there's additional due diligence required for the head of household status that was added just when the president signed the law earlier today. So under the due diligence rules, we have to ask extra questions. We have to fill out the 8867 form for really 4 credits: the earned income credit, the child tax credit, the additional child tax credit, and the American Opportunity Credit. And the Tax Reform Act that went into place added head of household to that. Hopefully you also are here and in many other Iowa Bar presentations to keep sure you're up to date on the law. Now, I'll have to pause here for just a second. I am suffering a little bit of a cold, so I'm going to cough and I'll be right back. Okay, thank you for your patience. So, you also have professional pressures: competition, the cost of doing business, keeping up with your education and your knowledge, and that's going to be particularly challenging next year. This coming filing season, there are some provisions in the law that you'll need to be aware of, and Iowa Bar is partnering with the Center for Agricultural Law and Taxation on the 24th of January to bring you the knowledge of what you need for the 2018 filing season, not the 18 tax year, but the 18 filing season, and some others as well. Do I charge a fee for an amendment? Do I take a client when I don't know anything about the issues? So you have decision making there. And we all justify our actions in our ethical decision making. You can see a number of them on the return. We'll talk a little bit more about this later when we get to the due diligence area. So why are business ethics important? Well, for a lot of years I've been teaching there's a big difference between a business decision and a tax decision. And this is going to be even more important as we move into the Tax Reform Act that just was signed into law, because we have so many opportunities here in the business area that there's a lot of changes, and sometimes a tax decision is not really a good business decision. When we look at bonus depreciation, when we look at 179 and things like that, we got to look at was it a good business decision, and if it results in a great tax decision, right. But in the past, I've seen a lot of people make tax decisions that aren't always good business decisions. So when you're working with your clients, think about that. So let's get into the nuts and bolts. Who is the Office of Professional Responsibility? Well, they've been around, really, as I've said, Circular 230 has been around since 1884, but it never really came to the attention of IRS until the early 2000s when Karen Hawkins joined IRS and realized there was this area that regulates professionals. So she really took it and made it into an important document. It was one of those like languishing in the code. It wasn't Title 26, it was Title 31. But you have responsibility to clearly communicate, educate your client. I've always said they need to know what questions to ask, so they have to have enough knowledge to know what questions those are. You should have a standard of competence on the tax returns for which you've been engaged, and act with integrity amongst your other professionals in your firm or those that you visit with, network with. So in looking at that, not only do we have Circular 230, we also have the Internal Revenue Code, Section 7701, that defines who a tax professional is. We have penalties associated with a variety of things that a tax professional does. We also have moral codes like the Iowa State Bar Association, Code of Conduct, standards and statements of practice. So it's just not Circular 230. There are several other aspects that as tax professionals we need to look at. Now you can see that Treasury Circular 230 applies to all these people you see on the screen and anyone who represents others in limited practice regulations, and includes giving advice with respect to an entity, transaction plan, arrangement, any of those things. There are 5 key sections. We're going to kind of skip through some of them. We're not going to go through every section. But basically the first section, the rules governing authority, that's what governs the Office of Professional Responsibility. The duties and restrictions of Circular 230 define what your responsibilities as a tax professional is. And then there's a section on sanctions and disciplinary proceedings, and we'll cover a little bit on that. Can I pause just a second? Okay. So as I said, I defined practice before the IRS just a little bit. Let's talk a little bit more about that. It encompasses everything you do within with the Internal Revenue Service and the Department of Treasury. with the exception of the preparation of a tax return. And you can see that on your screen there, preparing and filing documents, responding to correspondence, conferences, hearings, representing your client, any written advice, plan or arrangement, all of those are practiced before the IRS. Also, you are required by Circular 230 to have a PTIN. That would be a violation if you didn't. And if you haven't sent your PTIN in to Christy here at the Iowa Bar, she would like you, because she wants to be able to give you credit in the systems that we have to work with. Please email that to her so she can, when the session's over, she can conclude and make sure everything gets reported correctly. As I said, on January 1st of 2016, there were new rules that were put into practice concerning representation. Unless you're licensed, you can no longer represent your client before IRS, even though you may have signed and prepared the return. So what is a licensed individual? They are enrolled agents, certified public accountants, attorneys, have unlimited rights. Then there's the annual filing season program participants who took the test and have their certificate before December 31st of each year. And we have those who took the test with the Registered Tax Return Preparer program, who were grandfathered in, who must keep up a certain number of CPE hours each year. Now, they can represent, those last who can represent, but only if they signed and prepared the return. Anyone who isn't one of those that I just mentioned can no longer represent their client. And I want to caution you here, because I know some of you, as attorneys, not every attorney prepares tax returns. Some attorneys have other tax professionals that help them with 1040s or other types of returns related to your law practice. You might want to verify that these people are licensed to represent the client and that sort of thing, because we now have a vast difference between who can practice before the IRS and who cannot. So just something just to keep in mind. And here's a little bit more about that I was just talking about on your screen. And these changes, as I said, began in January of 2016. And notice what an unlicensed tax professional cannot do. They can't correspond or communicate. They can't represent the client. They can't prepare or file documents on the taxpayer's behalf or render any advice. They can still sign and prepare the tax return because it's not considered practice. But in your practice, and if you have engaged someone who is not licensed, this could impact your practice in another way maybe you had not foreseen. So it was just a reminder for you. Now, the Office of Professional Responsibility has several rights, and one of them that is defined in Circular 230 is their right to discipline, okay? They can censure, suspend or disbar anyone who has incompetent or disreputable conduct or fails to comply with the regulations of the Circular 230, or if there's intent to defraud, willfully means you willfully, IRS defined it as you willfully violated a known law, okay? Misleads, threatens, all of that. So they do have the power to censure, suspend, or disbar. Now, along with that, they also have the power to go in and do a monetary penalty. And when you look at the code sections, and you can look at those at your leisure outside this conference, it's only up to the amount of the charge for the engagement. But the other issue you've got to look at here as we dig deeper in the Circular 230, in the changes that have occurred in the last few years, it used to be that IRS could only penalize, censure, suspend, or disbar the one individual. They now have the authority to monetarily and charge penalties against the firm if there's a lack of control and that sort of thing. And just keep that in mind. Now, Circular 230 doesn't define ethics in any way. It's, like I said, most of us learned it from very young childhood. If we didn't then, we learned it at school or from a mentor, or when we got into the business world, we learned it then. It's all about integrity and character and honesty, and I added common sense. I sometimes think we forget about common sense, that we sometimes just need to step away from things and look at them from a different viewpoint, and we might see something. It's like we're so close to the trees, we can't see the trees, so to speak. So you face several scenarios daily that cause you problems. And I get a lot of questions on this at the center when it comes to ethics. Apparently people do have a hard time firing a client. Even if the client doesn't pay them, they'll often continue to do quite a bit of work for them until they just reach a certain point, and then they're still unsure sometimes about firing. It can be difficult also to decide when to accept a client. Depends on if there's any conflict of interest, if there's any issues that you're not comfortable with based on the information they provided, which could be tax returns or other information. You have to explain things, clarify issues, but to do that, you've got to make sure that you have all your facts and circumstances, your ducks in a row, and remember your client, and I sometimes feel I don't have to tell you this, but I get so many questions. Your client may not think something's important and doesn't tell you, and you may have to dig deeper. I know you should know that, but I sometimes think we forget to think about that. You also make sure your client understands the issues, especially if they're very technical. And of course, you deal with procrastination on a regular basis. So you need to know your limits. What can you not accept? Where do you draw your line in the sand? You need to ask more questions, dig deeper. And as always, and this next year will be even more of a challenge, keep up with the new law and be able to help your clients address those questions through the next year. So let's look a little bit more at incompetent and disreputable conduct. Since I was talking to attorneys today, I thought you might appreciate some of the information concerning if indeed you're ever get that letter from the Office of Professional Responsibility that you've been accused of something. You need to know, what do I do? What are my rights? Where do I go? How do I handle it? That sort of thing. Now, under Section 10.51 is where you start getting into the disciplinary issues with IRS. And there are 18 of them. And most of them, as you can see on your screen, have a negative context. So, and I don't need to read them. You can read them just as easily as I can. I do want to tell you, though, that 3 of them are brand new, and we'll look at those right now. Failure to file electronically. If you intend to file more than 10 1040 series tax returns, you're required to file electronically, and you have been since 2011. There's also electronic requirement filing for certain corporations and partnerships as well. So failure to do that can result in some sort of disciplinary action. If you don't have a P10, that's another one, and then representing the client without a power of attorney. We were very fortunate for about 5 years to have the disclosure program into e-services, where you could get the power of attorney from your client, upload it into e-services, and then it was right in the IRS system immediately. Well, IRS found out that many people did not have the powers of attorney in their files, and they terminated the program. So people were just inputting a POA without permission. That's a violation. You also have to keep up with your personal tax compliance responsibilities, and they've clearly defined those in the Circular 230. And I want to reiterate something here. I was just on a webinar yesterday about the importance of your EFIN, your electronic filing identification number. And a lot of people, we only had 15 people on the session. I was hoping for a little bit more, because just one thing can be wrong on that electronic filing application that is stored in the e-services area. Okay, you've got to go into e-services to make changes. IRS can pull the EFIN right in the middle of filing season, which seems to be the time of the year they generally do it, because that's when you need it the most. For example, let's say you have 10 people in your firm and 9 have filed their last 4 out of the last 5 income tax years, and 1 has not. They can pull the EFIN for the whole firm. So hopefully you've got some sort of policy statement where you have to verify that people have timely filed. Similar to 5 out of the last 7 quarters of any employment or excise tax or that sort of forms. And basically, I've had 2 or 3 of these cases where the firm had no idea one of their employees, a partner even, had not filed for several years, and the EFIN got pulled like in February. So you've got to be real cognizant of that. You also have what's called responsible officials that years ago you identified on the EFIN application. Those people may not even be there, and if IRS tries to contact them and they can't, they'll pull the EFIN. If you had a principal official, that's another one, besides the responsible official, who has died, and I get this quite often, IRS now knows when they die much quicker, and if you don't go in and change the application, it can also be pulled. Your EFIN can be pulled. So just a heads up on that, so you can avoid having to give me a call as to how I do get my EFIN back so I can e-file during the 2018 tax season. So subpart D applies to the disciplinary proceedings. So if you've had some sort of accusation against you, you can, you'll get what's first called like a preliminary letter. I want to make sure I didn't go too far ahead. And if you want, you can ask for a conference call. Now, if it's very serious, it won't be a reprimand. In other words, OPR has looked at the case. If it's serious, you'll be allowed to tell your side of the story, so to speak. Present your whole case in a very clear and concise manner. Basically, your side of the story. And remember, oftentimes perceptions are involved in this. So in some cases, not all, you can propose your own discipline. And if indeed they do censure you, it's the least they can do, okay, is usually a one-time public reprimand. Now, if you decide to settle, these are private in some sense, but they're still published, and that should say IRB. Sorry, I made a typo there. It's not the Internal Revenue Manual in the last bullet. It should be Internal Revenue Bulletin. But any information about any terms of the agreement are generally not published. But the censure can be, and let's look at our time frames here, just a one-time public reprimand. Now, if it's not a censure, which is the smallest that it could possibly be, it could be a suspension. So the suspension starts at 6 months and can go just under 5 years, whereas disbarment starts at 5 years. And this has nothing to do with your rules here at the Iowa State Bar Association. This is just within the Office of Professional Responsibility. And then there can also be that monetary penalty that we talked about, 100% of the gross income received. Now, if you do choose to settle and they accept that settlement, then as I said, only the events are generally made public. So it can be very little, like a censure, or it could be a suspension or disbarment. But if you don't agree with that judgment, you still have some opportunities. You can choose not to settle. Okay, so you've defended yourself, and you can choose not to settle, and you can commence a proceeding. And what you do is you file a complaint with an administrative law judge. Now, they're contracted by the Office of Professional Responsibility. So basically, there's no courts involved of any kind. There's a hearing scheduled, and evidence is presented, and you'll be allowed to make your arguments and present your evidence. And then they make a final determination. And then if you don't agree with that, you have 30 days to appeal. And that's to the Treasury Appellate Authority. And that's an arm of the Chief Counsel. And if indeed whoever wins the Office of Professional Responsibility, if they lose, they must accept that Treasury Appellate Authority's decision. They can't go any further. But you as the practitioner still have one more level, and you can file in district court. Now also, when you file in district court, then it's going to become public knowledge. So it's going to be, and pardon me just a moment. Sorry, Christy had to step away. So when you file in district court, as I said, it's going to be public information. And you know how the media is with things like that. So, but you will have an opportunity to have your say and present your side of the issue, having your day in court. Now, the standard of proof is willfulness, and I defined willfully and willfulness earlier. And you must prove clear and convincing evidence. It's lower than beyond a reasonable doubt, like we heard about in criminal cases, but the proof is more than reasonable cause, okay? Or probable cause, pardon me. Now, what is the person accusing you, let's say it's the taxpayer, what is their defense? It might not be the taxpayer. It could be the IRS, and the complaint was filed by a revenue agent. It could be the complaint was filed by another preparer who the client brought your work to them, and they realized it was rife with errors, that sort of thing. So it doesn't have to be the taxpayer. But the taxpayer's defense is usually blindfulness, okay? Why would you have put it on the return if it wasn't correct? I didn't know anything about it. You never told me it wasn't right, so of course I just assumed it was okay. And you never explained anything about this. You know, if it was that technical, why didn't you explain it? And I remember us discussing it, and you were saying it was okay, so I trusted your judgment, that sort of thing. Regardless, willful blindness will not work. The court will not accept it from either party, you or the accuser, so to speak. Okay, that gives you a little bit of information about your options if you ever get in front of the Office of Professional Responsibility. So let's go into some other important issues. And I kind of mentioned one a little bit ago, and we'll talk about it a little bit more now, and that's due diligence. Now, due diligence has been in the Circular 230 at least since I was aware of it back in the early days of the 1990s, 1996, 97. And it may even have been before then. But we've always had due diligence in the preparation of tax returns and the filing of the tax returns and any types of documents that we submit to IRS or Treasury. And you've always had to use due diligence to prepare correct and complete tax returns. But we have heightened due diligence now on some things, and we'll talk a little bit more about those in just a minute. Also, you've got to look at other work products of other persons. What's your comfort zone? The standard you have to meet there is reasonable care when you engage, supervise, or train, or evaluate that person. when you're looking at another work product, okay? So just keep that in mind. Reasonable care, act in good faith, that sort of thing. They're kind of connected together. Due diligence is not only section 10.22, and it's nothing new to us, but is also related to the section 10.34, which when it was added to the Circular 230, it's the standards of what you should aspire to, so to speak. As I said, you may rely on good faith, but you've got to use that reasonable standard without verification. But if something just doesn't feel right, okay, and it's furnished by the client, or you're interviewing the client and something isn't, you know, you've got this funny feeling or it just doesn't seem right, you can't ignore that. You need to explore the issue a little bit further and make reasonable inquiries about the information. One of the things I urge all preparers to do is when you, especially when you're sitting down to do the new 2017 return here in the next few months, or you take on a new client, go back and look at least the prior 2 or 3 years of returns. I've noticed that in my last few years of working, that as we get a little older, we don't remember things as well. So you could have elderly clients that forget to bring in certain 1099Bs or 1099Rs or, you know, dividend statements. They normally brought those in, and in looking at the prior year returns, you can catch that and maybe avoid a CP 2000 letter for your client. One of the new things that was added to the Circular 230 in 2014, that's our most recent version, is June of 2014, is competence. And when this was added, it was just like, okay, if they can't get you because you didn't furnish the information timely, or you didn't correct an error on an error or omission, they could get you on competence. In other words, you've been engaged for something that you have to have the knowledge and the skill and the thoroughness to prepare a tax return, okay? And you have to also show competence in representing your client, in educating and researching the technical aspects of that law, to educate yourself, know how it goes on the tax return. And you also have to be really cautious of the 7216 requirements that also have been around for years, and IRS heightened their interest in the disclosure agreements. 7216 is a disclosure issue. There are permissible disclosures and non-permissible disclosures, and I could talk a whole hour on that subject. But watch your competence, especially in a firm. You could have mentors in a firm, but you don't want to assign a case to someone like myself who's never done a corporate tax return and expect them to know everything about corporations. So let's dig a little bit deeper in this. Section 10.34 also states that you cannot sign a return or a claim for refund if the position on that return has absolutely no reasonable basis. So we can only assume, number one, you didn't do the research or you didn't know what you were doing, okay? Or number two, which is the position is unreasonable, and it's defined that way under 6694, but you still took the position knowing it was an unreasonable position, or you willfully attempted to understate tax liability, or basically just disregard the rules and regulations. Now, that's something that came into place here just in the last 5 years was a case called the Home Concrete case. And that case had nothing to do with the understatement of tax liability. It had to do with the overstatement of basis. And Home Concrete won that case. What they did is they overstated the basis, which resulted in an understatement of liability, but when the courts looked at it, they said there's nothing that defines the overstatement of basis where they could charge the penalty for an understatement of tax liability. So what Congress said is that's not right. So now an overstatement of basis that understates income could be an understatement of tax liability under laws that were passed here about 4 or 5 years ago, right after the home concrete case. So it could be, if it's 25% or more, could be an understate of income because the basis was overstated. Therefore, the penalties will apply. Also, you've also got to look at substantial authority, and really, substantial authority starts with the code. It's not publications, it's not forms, it's not instructions, it's not notices, it's not frequently asked questions, okay? Revenue rulings and procedures are okay, but the code is your core document. You also, if you advise your client to take a position and you prepare and sign the return, and they still want to take the position, you must inform the client of any penalties that could result from this. You can do the disclosure, and I think it's the Form 8275 for the tax code and 8275R for the regulations. So, pardon me one moment. So, what is an unreasonable position? It basically lacks that substantial authority that I just defined for you. And in 6662, but it has a reasonable basis and is disclosed. And those were the forms that I just gave you. Once you, for the purpose of the 230 disclosure though, if you advise the client of the position and that sort of thing, as I said, you also have to advise them of the penalties related to that tax return. Let's talk a little bit now about written advice under section 10.37. Let me see what my time is here. Good. In providing that written advice, first of all, you've got to base your advice on some reasonableness. Now, I don't like the word assumptions. I like the word facts and circumstances. So you have to consider all the facts. And as I said, some of your clients may think that something is not important and not divulge that, or you know, they don't realize the importance of it. So sometimes a little bit of education is also involved. And you also need to use reasonable efforts to identify those facts. You can't rely on other representations, statements, or findings. IRS is going with the 3 I's: incorrect, incomplete, or inconsistent. And that applies to the due diligence for earned income credit, for child tax credit, additional child tax credit, and the American Opportunity, and head of household is now going to be added to that with our new law. You can't take into account whether or not the return will be audited. So you can't play the audit lottery when taking that position on the return. So keep that in mind. Also, in written advice, you can rely on good faith of the information that your client gave you, and not only that, from another practitioner only if it's reasonable and you've considered all the facts and circumstances. I would also personally want to know, okay, if I'm relying on the other practitioner, have they really done their research? Do they have the code section? Did they look for court cases maybe, especially if it's very difficult case or unusual case? Did they look for rulings and procedures and things like that? You can't rely on anyone that you know is not competent or provides any type of advice that, you know, well, Bob down the road's been doing it for 20 years, so it must be right, that sort of thing. Okay, and attorneys especially, and we may have more than attorneys here today, you have other conflict of interest requirements that I didn't include in the presentation because I know your conflicts of interest are very concise and strict. Now, errors and omissions, just a little bit on this. If you know your client has not complied with the law, you're obligated, and I would advise you to probably put this in a written form, to advise your client of the error, the consequences of not correcting the error, and even go as far as providing the regulations for that non-compliance or omission or error, okay? And penalties, okay? Including any tax liability that may result, anything criminal, and you also always watch your statutes very carefully. Statutes have a tendency to get away from people, even revenue agents and tax compliance officers, same with attorneys and tax preparers. Now, under errors and omissions, you cannot make anyone file an amended return. So if they never file the amended return, you know, there's the Bratko case on that. The Supreme Court basically said you can't require them to file an amended return. They'll either want to correct it right away, they'll want to wait and see if IRS catches it, or they won't do anything at all, okay? They'll just take their chances. They'll play the lottery, so to speak. But you have an obligation. If you're not comfortable with the client, send it certified mail, because there's always that possibility that if indeed it gets audited, their story could be, well, I didn't know anything about it, okay? So it's always good to cover yourself with documentation. Also, furnishing information to the IRS, just be timely as you can. They're on very strict 15-day timeframes now, with an additional 15 days with manager approval once they get your information that they've requested from the information document request. And this is closely connected to submitting the documents. Oftentimes, you're not the problem. Your problem is the client can't get their act together. And you can't submit something unless your client has given it to you, okay? So keep that in mind. And this is closely, as I said, connected to handling matters promptly. Don't unreasonably delay. Don't lie about it. Just say, you know, my client hasn't gotten it to you. I had a case years ago. The person told me their mom died at least twice because they weren't able to get the information, and the mother had died, and then the second time they died again. And that was like 6 months after the first time. So don't lie about it. Client's records, you are required to promptly return the client's records that they ask for. Now, you cannot withhold records over a fee dispute. That is not allowed. Now, there's some state exceptions in that you can make copies of those records and still have them in your file. I'm not aware of Iowa having a statute, but I'm just telling you that some states do have that. But what is deemed to be client records? Now, client records are anything they gave you. It could be the W-2, it could be a 1099, a 1098 for the mortgage. It could be that 1098-T. It could be copies of prior year returns, all of those things. Okay, you're required to return those records or it's a violation of Circular 230. Do you have to give them the tax return that you spent 2.5 hours preparing if they didn't pay for it? No. None of your work papers are required to be returned as well, okay? They gave you an old depreciation schedule and you updated it, give them back their old depreciation schedule if they have not paid for your service. Okay, here is a little bit more on client records, and you can look through this. I kind of summarized it all for you. You're not required to provide them with your work product until, of course, they pay for the service. Do not negotiate checks. Even though you may have a trust account, You cannot negotiate, endorse, either electronically transfer or deposit any type of government check that has anything to do with federal taxes. Your client doesn't have a bank account, tell him to go out and get a bank account. Or he can go and cash the check at one of the many cash checking availabilities there are out there for people who don't have bank accounts or for whatever reason don't want a bank account. IRS tracks this very carefully, and just it's easy to spot somebody who does this negotiating a check. Supervisory responsibilities, this you may be involved in this, and you're required to give your P10 to the person you're supervising, because they indeed have to input it into their P10 application when they renew every year. And so you also, as a firm, you have principal authority and opportunity and responsibility to oversee that firm's practice, including the members, the associates, and the employees, and make sure they're in compliance. Like I said, I've had the cases where just one person in the firm hasn't filed for many, many years, and the firm's EFIN was pulled. The EFIN never can be transferred or sold with the practice. It's terminated, protected. There is issues where your EFIN could also be compromised. So check on e-services annually, and it will tell you how many electronic only returns that have been filed under that EFIN. And if it's off a large number, you may have an EFIN that's been compromised. A little bit about best practices here. I didn't put any of these in any particular order. Just communicate clearly with your client. Your term of engagement is, many people use engagement letters. I think they're a good idea because they define just exactly what you're preparing and what the cost is. In today's world, I think sometimes people think, well, once you prepare the return, then anything else that results, it's all included. And it's not like that anymore. Clearly communicate with your clients, establish those facts, what's relevant, what isn't, and make sure whatever conclusions you arrive at are supported by law. Also, you know, your clients, in doing this, you'll avoid penalties. Your clients will avoid penalties. Things will be accurate, and you'll be acting fairly and with integrity in practicing before the Internal Revenue Service. Now, to conclude here, I have 2 or 3 things I want to talk about, and these are a couple common questions. And this one has to do with returning records, okay? Following a disagreement, my client called, demanded his records back, is refusing to pay me. What are my obligations? Upon demand, you've got to return all those to your clients, the ones they gave you. If it's a dispute over fees, state law does control whether you're entitled to withhold some, but otherwise all documents obtained by the client, the third party, must be returned. So your state law controls at the state level, but remember, Circular 230, those documents all have to be returned. Now on this one, I want to, this is a real live issue here. So I want you to think about this one. This was a question that was on the Office of Professional Responsibilities website, where a business partner thought their other business partner was not really doing what they were supposed to, giving them tax credits they weren't entitled to. Apparently there were no type of policies in place for supervising or training, and they were concerned about, could he, the person asking the question, was concerned about if they didn't report it, can they be sanctioned for negligence or reckless action? And the answer is yes. IRS can, in certain circumstances, designate one or more individuals to be responsible for a firm's compliance. So if you had known or should have known that there's a pattern of behavior within that practice, then you can also be sanctioned. So it's just like, remember the old school days when one person is bad, the whole class got punished. It's kind of like that. Here is, I joined a tax resolution marketing service that refers representation clients to me for a fee. Is this type of solicitation allowed? And the answer is yes, but you've got to be very cautious about some of these referral systems. You can't accept or assist, you cannot assist or accept from any person who obtains the clients using false, fraudulent, coercive claims, misleading, or deceptive advertising. So watch that carefully. So I want to kind of conclude on a couple notes here. Ask questions. And we're in an atmosphere like right now that we have been over the past 4 or 5 years. Years ago, as a revenue agent, I had to justify I had to justify charging a return preparer penalty because they wanted it to stick, okay? Now, it's just the opposite. One of the provisions with ACA was that Congress stated that IRS was not assessing enough return preparer penalties. And now our revenue agents and tax compliance officers must justify not placing a return preparer penalty on the audit. So if something's suspicious, follow up on the issue. Okay, if something in your gut doesn't tell you it's right or you don't feel comfortable with your client's answers, educate your client as you go along, pick up on side comments, agents do. Make sure if it's a critical issue, your client understands it, and document, document, document. If you don't do anything else, that document could save you a little bit in the long run. And just to kind of conclude, I believe Christy has a polling question, and I'll turn it over to her for that.
I also have a question from somebody online. Even though you're not required, are you still putting the Circular 230 disclosure at the end of your email?
Oh, that's a good question. No, the Office of Professional Responsibility came out about 3 or 4 years ago and said that is no longer required and it should be removed from all email correspondence. And as a matter of fact, they were going to, it was so prevalent, they were going to start calling preparers and telling them to remove it. So no, the answer is no longer required to be part of the email issue that you're questioning. Okay? Any other questions? Okay, I'll let you do the survey then or whatever.
Okay, I've got the poll launched. If you just take a couple seconds, it looks like we're at 43% voting. I'll give you a couple more minutes here and then I'll shut it down here. Looks like we're up to 70% have answered the question. Just take a couple seconds to answer the question. Okay, I'm going to go ahead and shut the question down. All right.
All right, and I'm Christine Tidgren. I'm the attorney for the Center for Ag Law and Tax, as Christy said. And so I'm really glad you were able to be here on the Friday before Christmas. I know you're probably all here because you're so excited about talking about ethics for tax professionals. And I also know you probably have some ethics credits that you are short of this year. So we're really glad that you're joining us. So we're going to switch gears a little bit. The next section of the presentation deals with cybersecurity. And this has really become a big deal, primarily because it's become such a prevalent problem. Let me see if I can figure out how I need to switch there we go. It's just everywhere, as you know from your own personal life, not just in your business. Cybersecurity is touching really all of us. So there are certain steps we need to take. There are just things that we need to do to make sure that it doesn't impact our clients. And so today we're going to spend a good chunk of time talking about the risks of a cyber attack. Some of you may be well versed in this, some of you may be really up to speed on it, but we really need to make sure everybody's on the same page in terms of identifying the risk, because the risks have gotten huge, they're very prevalent, we just need to understand what they are. We need to understand the different ways that breaches can occur to our systems, what the different type of cybersecurity breaches are, what the impacts are if we have a breach. So we're going to take some time to sort of look at the different costs, both in terms of monetary costs, but also in terms of just loss of goodwill if we indeed have a breach. And then ways that we can manage these risks. So we're just going to look at some of the best practices that, in particular, smaller tax professionals can use to try to implement procedures and put policies in place that minimize risks and really protect your firm from being a target for these cybersecurity breaches. And the reason we're talking about this in an ethics class is because the IRS has deemed that this is a very significant problem. It's a very significant issue. And of course, the duty to safeguard our clients' privacy and security falls within our ethical duties. So it's an ethics issue. And IRS has said that identity theft and data security programs that help tax professionals identify these risks, become aware of these risks, and learn how to protect against them will qualify for continuing ed credit in the federal tax law category. So there's lots of reasons why we're covering this today, and it's sort of a timely topic for everyone who is a tax return preparer. There are also a number of legal requirements. We'll touch on some of these toward the end of the presentation, but here's just a few areas where we're subject to privacy, security obligations, couple of different laws, criminal statutes, civil statutes, also just various privacy statutes, privacy rules, safeguard rules. So IRS has rules, the Federal Trade Commission has rules. There are a number of places we need to look to understand what our obligations are. But let's just look at the landscape a little bit. In 2016, which is the last full year for which we have statistics, data breaches increased 40%. And I think we'd probably all agree that in 2017, that number is likely to climb even higher, just because it seems like we cannot read a newspaper or look at our Twitter feed without seeing another security breach or data breach somewhere. So it's a huge problem. Small businesses are at a huge risk. I mean, most of the time when we read about things, we're reading about the big guys, but most things that you study suggest that small businesses are at an even greater risk because we typically have less money, we have less time, we have less access to expertise to defend against cyber attacks. So don't think because, we're small or because you don't have a number of tax returns that you do that you're not a target, because most likely you are. Tax practices in particular are targets, right? And there's an easy database where people can figure out who has a PTIN, who prepares tax returns, and attackers will specifically target these people. And why is that? Well, it's pretty simple, right? Because you have what they need, and that's data. There's information for sale on the dark web all the time that gives criminals what they need to be able to go out and take out mortgages, you know, whatever. Personal data is the big commodity out there. And if you are in a business that brings in clients' personal data and uses that, then you're at a business that's at huge risk for a cyber attack. I came across this statistic that really I thought was a little startling, and I'm not sure if it's true or accurate, but 60% of small companies that suffer a cyber attack are out of business within 6 months. I mean, that's a really sobering wake-up call, not just in terms of if we let our clients' data out there, the impact it causes on them and the harm it causes them, but also just what harm it causes a business if they suffer a breach and all of a sudden all their clients' data is gone. Obviously, there are plenty of other options for clients. If they realize that their data hasn't been protected with us, they'll go elsewhere. So it's just something to consider when you're weighing the costs of implementing solid security practices. This little graphic came from the AICPA, and they pulled it from Continental Casualty Company. That's their insurer under their professional liability insurance program. But I thought this was really useful, that they analyzed their cybersecurity claims that were asserted against their policy for 2016. And they found that 35% of them were related to a network breach. 19% were related to actual stolen hardware, right, like a laptop. 21% were related to social engineering. Also, we call it phishing. We're going to talk a lot about that today because that's a huge mode that we're all familiar with, but there are some subtleties to it that we may not be aware of that causes a lot of harm. 12% were related to human error. 9% to ransomware, and 4% to other. So it's just sort of the breakdown in 2016. I would imagine these numbers would shift a little bit in 2017 from the types of attacks that we've been seeing. So in the next few minutes, we're just going to sort of go through some of the main ways that security systems are breached, the ways that tax professionals' computer systems can be accessed, and some ways that data can be stolen. We're familiar with a lot of these, but we're just going to kind of go through and give examples for those who may not be. So, right, the term hacking, that's a big one we hear a lot. We think of the creepy guy with the hood in a dark room somewhere, but really hackers are quite professional. They're found all over the globe, and they're very skillful, and they're able to gain access to almost any system, right, in the world. So we can't think for a minute that they can't gain access to our systems. We can protect our systems as much as possible, and we need to be aware of that, because those obligations that we have, right, we cannot recklessly disclose client data. And not protecting ourselves against the risk, or just thinking, well, it doesn't matter, I'm going to get breached anyway, would be reckless. So we have to think about those things when we're looking at what the risks are. So hacking is really just exploiting any vulnerability in a system to gain unauthorized access. And there's lots of things that can happen once they get in, right? If they get into your system, they can download a virus, they can get into an unsecure wireless system, they can gain unauthorized access to passwords, and we're going to go through all of these different ways that they can get in, and some of the examples of how this occurs as we go through this session this afternoon. And then they can just steal customer data, of course. That's the commodity that we were talking about. That's what hackers want. They want that personal data. But they can also just come in and shut down your system completely, and really sort of put you out of business at their will once they get into the system. A very common example that we're all familiar with, because many of us receive phone calls to say that our cards have been breached by numerous different companies that we've used. I mean, I'm sure many of you have had your credit cards replaced multiple times over the past couple of years. And the driver behind those the replacement of those cards is hackers breaking into the companies that process those cards and stealing the data. TJ Maxx and Marshalls, a couple years back, hackers broke into their system and stole 90 million credit and debit card numbers. 90 million. It's just a huge breach. And I started typing all these examples of things and breaches that have occurred in the last year, and I stopped right away because, you know, I could have gone on for pages and pages, as you know. But you see on this short list that I put together, just the wide range of industries that are impacted by breaches. I mean, and you see the common theme in these really is our systems that have personal data, companies that deal in personal data, healthcare companies, companies that use your credit card, right, that process a credit card, financial industries, all kinds of different companies that have actually been breached. And of course, then this year, we had the mother of all breaches, I guess, for now anyway, the Equifax attack. And we didn't find out about it till September, but it occurred way before then. And so here, this company that we all gave like great permission for them to have our data, right? No, I mean, they just had our data. They had this personal data, and they really should have kept it locked down. But that's not what happened. In fact, it was just a very simple error, apparently, from what we've learned, that the IT person forgot to install a patch, a simple Microsoft patch, apparently, that caused the system that houses all of our most personal data to be vulnerable to attack. And of course, I'm sure that criminals have had these credit processing companies on their radar for a long time, just waiting for a vulnerability to be able to strike. And so here was one. They came in, they stole the personal data of 143 million customers. Massive, right? Basically impacted all of us. Took 6 weeks to tell the public from the time that Equifax learned of the breach. There have been lawsuits filed, the CEO has been fired. It's just a massive mess. And then what happens when we found out about it? Well, we're supposed to go to the Equifax website and type in our social security number, right? And you'd go in there to see if you were breached. And so I've heard lots of different stories from people who did this, and they type in their social security number and it would say, no, you weren't breached. And then they go back the next day and they type it in and say, yes, you were breached. I mean, it's just a crazy thing. Hard to know exactly what to do in the wake of something like the Equifax breach. Commissioner Koskinen, who just left his job last month, had made a statement, though, that in a way kind of suggests, well, maybe it doesn't matter. What he said is, you should assume that your name, address, and social security number are already in the hands of criminals and act accordingly. So that's not to be pessimistic, but just to say, I think we all, in our business lives, in our personal lives as well, need to be aware that our personal data may be out there. And so what are the ways that we can protect ourselves? How do we advise clients to protect themselves in the wake of this invasion that we have of data theft? And so one of the ways, I think one of the biggest ways that it seems like we can advise our clients and perhaps advise ourselves as well, is that credit freezes may be the best solution to really sort of batten down the hatches and secure our personal information. And if you haven't investigated this, you might want to. There are lots of reporting services, there are monitoring services, and those may be well and good. I'm not in any way discounting them or saying that you shouldn't subscribe to one or use one. However, I have heard those described somewhat as the doors are open all the time, and when the thief walks in the door, you get a call to alert you to that intrusion. Whereas with a credit freeze, everything is secure in terms of no one can go out and take out a loan in your name. No one can get a mortgage in your name. You know, it's a little bit of administrative hassle. It's a little bit of monetary hassle, but it may be something strongly to consider looking into. Another thing is regularly checking your credit report, not to look at the score. The score is really not the important thing. The important thing to look for is, have there been businesses or people that have tried to access or have accessed your credit report that you don't recognize, that you haven't been out soliciting credit, so there really shouldn't have been an inquiry. So if you sort of regularly monitor the checks on your account, you could know whether someone else is perhaps applying for credit in your name. Another suggestion IRS has made is to create a My Social Security account online with the Social Security Administration. And the reason you do that is you can check the income that's been attributed to your Social Security number and see if somebody's gone out there and gotten employment in your name. So those are just some things that you can think about as you advise clients and you advise yourself just about how to protect yourself in the wake of this environment in which we're in. What about freezing credit? You know, what's involved? Well, it's really not a complicated process. If you're not somebody who's always going out seeking a new credit card, or if you're not at a place where you're out to get a car loan or buy a new home, it might not be a bad idea just to put that credit freeze in place. It takes about 20 minutes to contact the 3 different credit bureaus. And in Iowa, it costs $10 to put the credit freeze in place. Now, if you're a victim, an identified victim of identity theft, then the credit freeze is free. If you need to temporarily lift the credit freeze, it's going to cost $12. And if you want to permanently lift it, it will cost $10. So there are some costs associated with it. However, no one's going to be able to get in and access the credit bureau on your, using your data if you indeed have a credit freeze in place. And then what happens is when you put the freeze in place, they give you a PIN number. And then when you need to lift it, let's say, we're going to talk in a minute about EFIN, that would be a place when you go in to renew your EFIN and update your EFIN number, you can't have a credit freeze in place. So if you have a credit freeze in place right now and you're planning to update your EFIN in the next week, you will have to lift your credit freeze. And so you'll need that PIN number, and you type that in and they'll lift the freeze temporarily. And then you can put it back in place whenever whatever transaction you needed to do is done. So let's look at the next type of, I guess, breach that's really a huge one this year. It just seems like those of you who are on email service from IRS, it just every other day, it felt like this year, we were getting emails from IRS with another phishing scheme. And it can kind of be the thing where you roll your eyes after a while and you're just like, oh, well, this, I'm just kind of tired of reading about this. I don't want to think about it. And so we all know what an email phishing scheme is, right? At its core, it's an email, it comes in, it looks legitimate, but it's designed to steal information. It's designed to draw you into some compromising situation, either to breach your own system or to entice you to give personal information to someone else. So in 2016, now these are 2016, not 2017 numbers, IRS had seen a 400% increase in phishing and malware incidents. So I can only imagine what that increase will be for 2017, because it seems like in 2017 was when we really started getting all of those warning emails with examples. So we can start with the most basic and targeted, right? They call a targeted phishing scheme spear phishing. What it is it's just something that's targeted to you. So we'll talk a little bit more about some other examples, but one very simple example that's a true one is a gentleman got hired by a bank. He was a new employee. It was all put in the paper. Everybody knew he was a new employee at this bank. And so someone devised a phishing email that posed as and masked itself as being the head of HR at this new bank, and sent it to the new bank employee and asked for his date of birth, asked for his social security number, and he responded, right? Because, oh, hi, you know, nice to meet you. I'm sure I'll walk down the hall and see you in person pretty soon. But for the moment, he just sent it right back, and there was his information disclosed to the criminal. Again, the AICPA publication that was dealing with cybersecurity this year had another really interesting graphic that I liked. This one was talking about phishing, and I think it has some surprising information. It says 1 minute and 40 seconds is the median time it took for the first recipient of a phishing campaign to open the malicious email. So you send out one of these campaigns, less than 2 minutes, the first person has clicked on it. Then 30% of phishing emails are actually opened. Now that one kind of surprised me. It shows that these criminals are pretty good at making enticing emails. We at the center, many of you may be on our mailing list, we send out a newsletter list, a newsletter once a month with important things that have happened in the tax world and the agricultural world. And we're always really happy because our marketing statistics tell us that like we get about a 45–50% open rate, and we always think, well, that's really good, that they tell us at Constant Contact that's a good open rate. Well, then I saw this and I see that 30% of phishing emails are opened, and I didn't feel quite so good about that statistic, but 30% are opened. And then the real kicker to me is that 12% of the people who click, who open the email actually click on the link or the malicious the malicious download or whatever it is that was in that email that was intended to cause harm. So 12%. I think that's a really high, dangerous statistic that really signals our need for more education in this area. So a lot of you are like me, I'm sure, where you think, okay, phishing, those, we're past that. We're too, we've got that figured out by now, right? Here was one of the early phishing emails where, we pride ourselves, oh, we're a little sophisticated. We can identify these because look at the from, right? It's irs.update.com. We know that it's not like that. It's irs.gov. And then, of course, too, we just can kind of tell by this email that was from 2015 that there's just something not right about it, right? There's not the right logo. What they're saying is that they're asking you for missing information so they can give you a tax refund, right? We're past that point. We kind of realize that IRS isn't going to be doing that. Now, some of our clients may need more education in this, but then they're asking you to click on the link to verify the details. So, that's kind of the early thing. Here's another one from sort of early days of phishing emails, right? This is one, they put in some technical code that somebody that might not understand IRS is saying that a 501c3 is actually eligible to receive a tax refund, which was just kind of funny in and of itself. But I guess if people don't understand the code, they might not understand that's ridiculous. And then if you sort of look at the whole idea of this particular email, they're trying to make it sound very complicated and all of that. But again, to access the form so they can send you a tax refund, you click here. Again, this is old phishing. This is the type of phishing email that we kind of have learned that, oh yeah, we know not to do that. But things are different now. Things are more sophisticated. And this is what I want us all to understand because it's kind of jarring. So in October of this year, October 2017, many of you may have received an email that came from eServices, and it came from eServices registration. Apparently, it really looked like it came from eServices registration, and it was titled exactly like an email from eServices registration would be titled. Important information about your eServices account. And then the email said this: we are rolling out a new user agreement, and all registered users must accept its revised terms to have access to eServices and its products. Tax professional gets this email. It looks legitimate. They think, wow, I need to have access to eServices or I can't file my electronic returns. This is my business. And so you click on the review and accept a link. Well, when you click on the review and the accept link within this email, it took you out to what looks exactly like the registration scheme for eServices, except that it wasn't. It was a registration system created by the phishing criminals that was seeking your login and password for eServices so that they could use it for their own purposes. Which typically isn't that they're going to go out and use it. Again, like we've said, they're going to take that list of information they collect, they're going to put it up for sale on the dark web, and they're just after the money. And other criminals are going to pick up that data and go in and seek transcripts and try to file returns to get fake refunds. I mean, there's a whole host of information that can be gathered and a whole host of financial crimes that can ensue once you have an eServices login. And so they'd steal the login and password information. You may not even know you did this, right? And so some of you may have done this and you may not know it because it wasn't like a big red light went off, right? You just clicked on the link, you went to what you thought was eServices, you logged in, and then once you were there, you authorized that, yeah, you agree with this new user agreement. If this is ringing a bell as to something that might have happened in October, you might want to go back and look through your email to see what you did, because there were multiple emails coming in from IRS dealing with eServices during that time too. And they may have been somewhat indistinguishable. But for those tax professionals who did click on the link, IRS says that you have to hire somebody to conduct a deep scan of your system, and you have to contact the IRS e-help desk to figure out what your next steps are. Because what happened is they got in, and they also might have planted some code on your system that will allow them to collect data moving forward as well. And so it's important that that all has to be purged before IRS will allow you to continue to use your system for access to eServices. So it's just it's become extremely sophisticated. One of the scary things is that the average time it takes from a security breach to the time that you discover the breach for tax professionals is more than 200 days. So like I said, this isn't the old days. Some of you may still be back in the old days where you're thinking, oh, right, if I have a breach or if I get a virus or something, I'm going to start getting all these weird pop-ups on my system and I'm going to know about it and I'm going to call IT and they're going to come and we'll get it all fixed. That's not what modern cyber breaches look like. Modern cyber breaches are stealth, right? They come in, they just sneak in, they plant themselves within the system, and they realize by doing that, they can do the most damage, right? And we'll talk about some things that they can do in a little bit. But IRS is estimating that as of right now, about 3 to 4 tax professionals are being breached each week, just on an ongoing basis. So it is a real threat. One thing, if you're concerned about eServices and the security of your eFIN, is that IRS suggests running a regular e-file acknowledgement report. You can run that acknowledgement report just to make sure that no one's taken over your account. That lets you check your eFIN status. You can also check your PTIN account. you can, if you file more than 50 returns in a year, then you can go into your P10 account, you can look and make sure that the number of returns being filed under your account looks accurate, that if you typically file 500 returns, that suddenly it doesn't show that you filed 1,000. So there are tools that are available that can help us monitor these things, just to sort of keep an eye on whether somebody's out there using our numbers. Because, you know, they can file returns, they can request transcripts, and if you catch it early, you can stop those returns before they're processed. But of course, if we don't, then the damage is done to our clients. And the really crazy thing about that email that went out pretending to be from eServices, and the reason it was so effective is because, as you know, IRS is updating eServices, right? It's been a huge process. They have made it very well known to tax professionals. They even shut the system down at the end of October to try to transition to a new platform. And then now a whole new registration and login has started as of December 10th. So you have now been getting legitimate emails from IRS saying that all eService users must re-register and create new eServices accounts. In these new accounts, they're going to use this new, more rigorous two-factor authentication process. It's called Secure Access. And so all of these IRS electronic systems are going to start using secure access. And so the hallmark of this is really there's going to be a requirement for two-factor authentication, which is a password's not enough. You're going to have another layer of security on top of that. So those are legitimate. That's real. IRS is doing this in response to some of these attacks that have occurred that have compromised EFIN. So hopefully this new system will go smoothly. Everybody, I think Christy told you earlier, all tax professionals have to go in and do this, or you won't be able to use your EFIN come tax season. So this is important, but go directly into the eServices system. Don't be clicking on links in emails to get there. I think that's one of your best protections against phishing, and we'll talk a little bit more about that as we go along here. So one thing that I mentioned is if you do have a credit freeze in place, you are going to have to lift that temporarily in order to go in and re-register for eServices. And that's because this whole eServices re-registration is a big deal. So when you go in to secure access, you're going to have an email address, you're going to have your social security number, your filing status, and your last address from your last filed tax return. You're going to have to also include a personal account number from a credit card, a home mortgage loan, or a car loan. So you're going to they're going to actually be accessing public data from your own credit information just to verify that you are who you say you are. And then you also have to have a readily available mobile device. And if that telephone is not registered in your name, if it's in somebody else's name, you won't be able to use this easy process of getting an authentication code through your cell phone. You'll actually have to get it mailed to you, and that will take a little bit longer. So just be aware, if you haven't gone on to eServices yet to re-register, it will be a little lengthier process than before, but the reason is because of all of this cybersecurity threat that's out there and all the attempts to breach eServices that have been going on. Another problem that IRS has been having that you may have encountered, you may have had clients that have come in bringing you a letter that they received from IRS. And here's what's going on with that. That's with the CAF numbers, the Central Authorization system, where you have third-party access. So your CAF number may possibly have been compromised. IRS was concerned that there were some stolen CAF numbers. And then, of course, once somebody steals a CAF number, they can file phony disclosure authorization forms and request transcripts and do all kinds of things under your under your number. And so we know this because IRS recently, I think it was in November, they sent out 11,000, they called them random letters, to taxpayers to verify that yes, indeed, they had given third-party authorizations to the tax professional listed in the letter. So you may have had a client come in showing you this letter. It was legitimate. The client was just responsible to say, yes, I did authorize this, or no, I didn't. And so the whole reason for the letter was just to make sure the validity of CAF numbers, since it appeared that perhaps some had been compromised. There's also one other cyber scheme, I guess, that IRS has been warning tax professionals about, wanting them to tell their clients about it. And particularly payroll professionals are the ones that need to be warned about this. And so what happens, and this is something that IRS just put out a call last month to say, hey, up education on this because this is taking off again. It's a scheme, it's been around for a couple of years, but apparently hundreds of thousands of employees were victims this year. There's been a huge uptick in attempts to use this method. And so what happens is an email goes out posing as a company that's sending an email to their payroll company saying that they need a list of the names and W-2s of all of their employees. So basically it's just going to the payroll company saying, hey, can you send me this information? The payroll company responds, and we just need to make sure that everybody understands this type of information is not going to be requested via email. It should never be requested via email, and if anybody ever requests it, don't give it. Call them on the phone and figure out what's going on. So IRS has a lot of information on its website about this particular scam just because it has been particularly effective this year. So what do we look for in emails? If we can't, you know, especially that one that looked like it was from e-services, well, there's a couple of things that can protect us, right? Of course, the obvious first. If an email is asking you to log in or give personal information, even if it appears to be from a trusted source, don't do it, right? And so sometimes, I mean, I suppose a bank may legitimately send you an email with a link to it, but don't ever click on that link because we just don't know for sure. There are always third-party ways outside of the email to verify and validate that what's said in that email is accurate and true. So, you know, email addresses, as we know, can be spoofed. And in the old days, they'd spoof them wrong, and so it kind of tipped us off. Hey, that's a scam. We know that, but they're not so dumb anymore. The cyber criminals have really become sophisticated. We should watch for anything that's a download, anything that's a link. They say an unsolicited or an unexpected link, right? So I'm almost to the point where I'm afraid to download or click on anything unless it's something that I'm working with a colleague about. Again, you just have to be so careful, I think, in email now because these downloads are so easy then to penetrate the system. If they can get you to click on the PDF file or if they can get you to click on the link, they've got you. They don't even have to necessarily have you type in personal information. And back to that earlier slide, you may not know for many, many, many days that your system has been compromised. You may not know until your clients have had a false return filed under their Social Security number, because that's how these schemes work. Of course, we also know just from the old time phishing emails, a lot of times these things would threaten suspension of an account or something like that. And really that's what the e-services email was doing, saying, hey, you need to do this now or you won't be able to use it. So if there's something that's coming from IRS, the best thing to do is go to the IRS website and type in the search box whatever it is that they were emailing you about, because they will have a web page dedicated to whatever that is. If it was something that they were sending an email out about, they're really good about also putting that information on a bulletin on their website. So we can always validate these things. We don't need to click on links. There's also a lot of spear phishing going on, using emails that certainly look like they're coming from other trusted sources as well. So we've been talking about IRS, but there's all sorts of schemes, right? Here's one that's been going around a while, and it's been quite successful. A client, a potential client, somebody you don't even know emails you, but it's just, you know, it's John Brown, and he's just a person who's saying that they would like to be your client. Attached is my basic financial information for 2017. I would like to become your client, but can you shoot me an email after looking at my data to kind of give me an estimate of how much you would charge me to do my return? I mean, those are the types of emails that the criminals are sending. So if John Brown emails you without any other contact information, don't click on the download, right? Don't download his personal information. You could just send him a reply to say, hey, you know, can we talk on the phone and sort of figure this out that way instead, because you don't know who that is. And so I think that's one of the scams that's been successful, posing as a potential client. Also, we've talked about IRS, but other companies, familiar banks, your tax software provider, right? If Drake or Lacert or one of your tax software providers emails you, you know, asking you to click on a link to reset your password or to re-enter your PTIN and personal data or whatever it is that they're asking you to do, be very careful, because I think most legitimate businesses have wised up now that they know that they shouldn't be sending you emails asking for personal information. They're going to do that by directing you to they're going to have other ways of doing that. Could be your cloud provider if you're on the cloud. Also other practitioners, that's also a common tactic apparently used. So they'll pose as, instead of a potential client, they'll pose as a new practitioner that you don't know. And they'll say, you know, your former client so-and-so has given me this authorization, which is attached. Please send us the tax return information for 2016. Again, verify, validate, make sure that is a legitimate email before you download. I think my rule now for myself after studying this the last year or so is just, if there's a link in an email, don't click on it, right? I mean, very, very few instances should we pretty much feel safe clicking on links in emails. So if we know it's from a trusted source and it's not something that's seeking any information, we're probably safe. Downloads we have to be super careful of, because the download can instantly install the malicious data. So we have to really make sure that we were expecting an email with a link, and we have to really ensure that we were expecting an email with a download. A couple of other things I'll just mention that aren't as important for most of us in terms of tax preparation. There are other attacks called denial of a service attacks, and these won't so much shut down your business per se, but they could shut down maybe your tax software provider if you do it online or if you're on the cloud. That's, you know, when the cyber criminals just flood a particular web page with so many requests that we shut it down. We've all heard the big public ones about, I think Bitcoin website got shut down, and there have been shutdowns of Twitter and social media and Netflix and a bunch of big name companies through this method. Another thing, right, when we're talking about phishing and the importance of not downloading files that we don't know for sure if they're valid, the reason is because as soon as you download one of those files, there can be malicious code implanted on your computer that can either give instructions to destroy data, corrupt data, most likely steal data, because that's how they make money. The software can just sit on your computer and collect keystrokes, right? Think about the wealth of information that could come from collecting keystrokes. It can just do all sorts of things. One thing too that you might want to think about that sometimes we overlook are printers in our offices, right? We think about unsecure wireless, but if we have a wireless printer, you know, that printer stores data too. And so we just have to be careful to think about the whole of our systems, to think about the different places where there are threats. So there are other things too, of course. We have the viruses, Trojan horses, ransomware. Some of you may have been sent ransomware messages. We've had calls and contacts from several tax professionals in Iowa this last year who were hit with ransomware. A couple of them paid and they did get their files back. IRS says don't pay, that usually it doesn't end well. But ransomware is another thing that goes on as well. Spyware, adware, you know, that's kind of the type of cyber breach we think of maybe from the 90s, where we had all these little pop-ups that were just annoying, but they weren't so destructive. But those things can now be more destructive. They can collect personal data from our clients and cause destruction. Another problem that we need to consider is just theft of hardware. Right? So if we're thinking about breaching of our online systems, just the old-fashioned stealing of a computer can cause huge damage. And so all of our computer systems need to be locked down and encrypted so that if somehow they broke in and stole our hardware, they still wouldn't get what they wanted. And think about laptops, but also think about smartphones, tablets, right? Are we allowing our employees to take their smartphone and be able to access systems from work on a smartphone? These types of things all need to be thought through with a professional just to make sure that we're not leaving a door open for a breach. Just a government example, right? A Veterans Affairs employee just a couple years ago, he got his laptop stolen from home. He took his laptop home. For some reason, he had the unencrypted data of 26.5 million veterans, including names, social securities, and databases. And date of births, and that was all stolen. So we have to be not just thinking about ourselves, we have to think about our employees, we have to think about maybe they're not as aware of these issues as you are, because employees do make a lot of mistakes. We all do, and everybody has a different level of knowledge or understanding about the risks that are out there. So we really have to make sure that our whole office is educated, because we're only as safe as our weakest link. And so employees can unknowingly download malware, right? Click on email links, all of those things. I mean, here's a horror story from the Boston Globe that almost seems untrue, but it is, right? So we had an employee from the Boston Globe that was using recycled paper to wrap newspapers, but the recycled paper that they used was a printout of all of their subscribers' financial data. And they used them as routing slips for the newspapers, and they went out in 9,000 bundles all across Boston. And so apparently all of the financial data for 240,000 subscribers was disclosed. And we give these examples just to show that, you know, we all just make stupid mistakes, and we have to guard against that. Here was a sobering statistic too. Apparently 8% of breaches occur actually because of a disgruntled employee. So it's not just enough that we have well-trained employees, we also have to stay on top of our employees in terms of a trusted person can do great damage if they become an untrusted person. And unfortunately, that's a reality we have to be aware of. So again, important to do background checks on employees, use good organizational management. So those are sort of the big risks, right? So what can we do about it? Because if we have a breach, what happens? Well, we're going to have a whole bunch of costs. We're going to have to hire an IT professional to detect the problem and deter it. We're going to also, the IRS will require us to hire a forensic accountant That will actually be a requirement to determine what, if anything, was taken from our clients. Then we have all the costs associated with replacing whatever systems we need to replace to contain the damage, just to install new software, new hardware to prevent it in the future. Just a lot of different costs. Not to mention the external costs to our reputation, the downtime to our business. I was watching a webinar from IRS a couple of months ago that they did about this topic, and they had a tax professional on that webinar who had lived through this. And he said he spent the better part of 3 or 4 months just having to unwind and clean up from a data breach that occurred. And his story was just kind of like what we've been talking about. He had a breach. The criminals had installed software on his computer undetected. He didn't know that his data had been breached. He had no idea for many, many days until it was discovered. And then once it was discovered by the internal IT people, they reported it to IRS. The forensic accountant actually discovered that the breach had occurred way before the IT professional thought that it had. And all told, it cost about $30,000, and that wasn't the cost to his time. He had to spend a huge portion of his days for a 3-month period on all the hassles. And this particular preparer actually had insurance. And he was talking about the importance of that insurance because they did pay for the costs, the nearly $30,000 costs that he had to clean this up. But of course, no insurance is necessarily going to give you your time that's involved. But it might give you some repayment for some of the downtime that you have, some of your lost profits, those types of things. So let's look a little bit at risk management, what we can do. And so sort of the big things are kind of common sense, but it kind of bears probably repeating, sort of highlighting what the important things are, right? Even if we're small, if we are preparing tax returns and we're using electronic systems, which I haven't come across any tax professional that only files returns by hand in quite some time, we need to hire an IT consultant unless we also are an IT consultant. So some tax professionals are IT professionals. The skill kind of goes hand in hand sometimes, but unless you're one of those people, you probably need to, and I don't mean a full-time employee, nobody can really afford that unless you're larger, but you need to hire somebody who will not only come in, install what you need, but also be available and on call to work with you as needed. I think that's really important. There should also be good agreements in place with any third-party vendors just to make sure that they would indemnify you for breaches caused by their negligence, make sure that they're complying with all of the security policies that are required for your business, make sure that they're installing those patches, right? Employee training is really important. Again, conducting background checks. It's not enough to sit in a training session and say, don't click on suspicious email because it probably won't penetrate. Consider, testing the waters even. I've read that some have tried to send out emails just to kind of see who clicks, right? To see if their employees are taking the bait. And so there are different, interesting ways to sort of help your employees see that and understand the risks involved with these. Be super careful about unprotected access points. Make sure that your employees aren't accessing your systems. Make sure it's not allowable and not possible for them to be on an unsecured wireless accessing client data, right? We have to have all these procedures in place. For a lot of small firms, it is probably wise to think about or investigate moving to the cloud. Now, a lot of people get really nervous about that because they think, well, now I'm just exposing my clients to a whole new set of risks. And maybe that's true, but The reputable cloud providers, they're going to be requiring two-factor authentication. They're going to likely have a secure online vault. They're likely going to have security procedures that you as a small preparer likely can't afford to have on your own. And so that does seem to be a viable, prudent method for some smaller tax preparers to be able to meet their obligations. And on the attorney side, all of the attorney general opinions that have looked at that have said, yeah, that complies with ethical duties. You're not risking your client's well-being to go onto the cloud. Encryption is important. What about passwords? We have to just kind of rethink the password, right? Some of us may still be stuck in the days where we were trying so hard to come up with a password that we would remember. That maybe it's something like tax123, right? Well, the software that criminals have now is so sophisticated. It's called brute force attacks. They can spin through just endless combinations of common type of passwords. So, you know, you'll be discovered if you use a password that's sort of basic or has, you know, numbers in a row. Actual recommendation, which makes me cringe because I can't imagine typing in this long of a password, is 16 characters, alpha, numeric, and special. Apparently that's sort of the safety zone, 16 characters. So some of you may be there. I'm not yet there, but that is the recommendation. And then the key thing seems to be two-factor authentication. So that's the thing that got Deloitte in trouble. You may have heard a couple months ago, Deloitte, obviously a huge firm, announced that they had had a 6-month breach. So there had been a breach in place, 180 days, they didn't know about it. It stole personal data from 5 million emails, a lot of that client data. And how did they access that information? They accessed it through the email account of their network provider who did not have two-step verification. So they used one of these brute force attacks. They figured out his password and they penetrated the email system and they stole all that data. So, you know, just kind of some basic things. You can't recycle laptops. You can't recycle smartphones that have had any personal data without actually knowing what you're doing and working with an IT professional to make sure that that data has actually been really wiped out, not just sort of deleted in a way that people who know what they're doing can go in and find it. So what are the steps to take to really make sure that you're protecting your system? Well, every tax preparer needs to have a written response plan. There's a whole bunch of resources out there. My slides will give you those resources to look at to see what's included in the plan. But basically a recovery team, who has to be contacted. Because, right, if there's a breach, you are under an obligation. You have to contact local police. You have to contact law enforcement. You have to contact IRS. You have to contact credit bureaus, and you have to notify your clients. That's state law. It requires you to notify your clients if their personal data has been breached. And so that's not an easy call to make, but it's one that has to be done. You have to coordinate that with law enforcement because you don't want to compromise the investigation. The slides give you the citation to Iowa law that defines what unauthorized acquisition of personal information is. It also includes what is personal information. Of course, the basic things that you'd think, your social security number, a driver's license, those types of things. One thing I want you to think about if you haven't is cybersecurity insurance. I've been talking to a lot of tax professionals this fall and I'm hearing a lot of different stories. A lot of people are moving to this protection and they have found it beneficial. Now, the one thing I will say is that early on, about a year ago, it was fairly cheap. It seemed like the extra protection that you have to pay for to get cybersecurity protection insurance was pretty reasonable. It seems to be going up in price all the time. So it might be something you might want to check out sooner than later because it might continue to increase in price. but it is something that adds an extra level of protection to you. It gives you somebody to help you in the event that you are breached, and gives you a little bit of financial security. The slide here, knowing or reckless disclosure, this is just citing to the Internal Revenue Code provisions dealing with both the reckless disclosure of personal information, which is a criminal violation, as well as the civil provision, IRC 6713, that imposes civil penalties for preparers who disclose personal information of clients. And then, of course, there's Rev Procs in place that if you're an e-file provider, you also have to have security systems in place. If you haven't developed an information security plan, you need to do that. IRS Pub 5447 is a great resource. It provides a list of helpful information that you can use. One more resource I want to add to that is the Small Business Information Security, the Fundamentals. That's what that resource is called. It's on the National Institute of Standards and Technology website, and I have the website there, nist.gov. I think it's a great resource for creating an information security plan. It has some helpful checklists. It has sort of a rough plan that you can start from. But that's something that everybody really needs to have in place, and just kind of stay up to date by subscribing to IRS emails. Look at your quick alerts, read those things that you get so that you kind of are in the know about what's going on, so that if a criminal tries to send you an e-services email, that you can kind of know enough to distinguish between what they're sending and what IRS would be sending. And again, don't click on the link directly. Go to the IRS website and enroll in e-services that way. So that was sort of a quick spin through of some cybersecurity issues. I really appreciate you guys being here today. I'm going to give you the numbers again in case you need them. The activity ID for Iowa attorneys is 269879, and the IRS identification number is Y7WRM-E-00217-17-0. And if you didn't catch that, you just feel free to email us and we'll provide that to you. But thanks for being here this afternoon, and have a great holiday season.